today we want to talk about the Texas Department of Public Safety. They're responsible for issuing driver's license in Texas, and they claim they have a new rule that says that you need to have a valid visa stamp in your passport in order to get a driver's license in Texas. We'll talk about who that actually applies to and whether they're even correct based on their own state law. And then we'll update on the $100,000 H-1B fee, where it stands in litigation right now. Do you have to pay it? Do you not have to pay it? What should you do if you're getting ready to file in the cap and you are subject to the fee? And then we'll talk about planning for the potential layoff, planning for the potential employment termination if you're an H-1B worker, what you should be doing while you do have the job so that you can be prepared in the event that worst case happens and you find yourself without a job the next day. What steps should you be taking to make that process smoother and be prepared for it? Lastly, for people that are with the same company, but job title changed, duties change, and you are into the perm process, your perm is maybe already filed or already approved, maybe even your I-140 is already approved. How does that impact your already approved perm or pending perm? And do you need a new perm in that situation in order to continue your green card process?
First of all, Emily, what's going on in the DPS, the Texas driving license? I am right now moving from Florida to Texas. I have my H-1B stamp in the passport, which expired in 2025. I have my H-1B extension with the Texas LCA, valid until 2028. Why are they not giving me the driving license?
Yeah, so the weird thing is it has nothing to do with proving your status, which is usually the problem that we experience with people renewing their driver's license and applying for the driver's license, is that each state decides to, be their own immigration officers and look at your immigration documents to decide whether you are lawfully in the country or not. Here, they're actually using it as an identity document. And so they're claiming that in order to prove your identity, your passport is not enough, even though it's valid. You need to have a passport plus a visa stamp, both having your photo, both having your birth date and your name on it. But they won't accept the visa unless it is unexpired, which does not seem to be in line with what the actual Texas state law says. Stephen Brown and I had looked it up a few weeks ago when people were starting to report this problem. And the statute's written very clearly that you need to have a valid passport and a valid or expired visa stamp so that they can verify your identity. But when that gets translated into the DPS website and into all of their various brochures about proving your lawful presence and improving your identity, some of them will just say you need to have a valid passport and visa, which they make it sound like you need both to be valid, or they sometimes say valid passport and valid visa, which is not actually what the law says. And again, it's to prove your identity, not to prove your legal status. And so for people who are already in Texas, already have a Texas driver's license, and you are applying for your renewal of your driver's license, you should not have any problem, because an alternative to proving your identity is your currently valid Texas driver's license. So if you already have a Texas driver's license and you're renewing, this doesn't seem to be a problem. It's for anyone who is new moving into the state and trying to apply for the driver's license. They're not accepting driver's licenses of other states to prove your identity, which means you have to rely on your passport, and they'll only accept that if the visa stamp is also valid, which does not appear to be correct. We have not made any headway in trying to get them to fix that. We've reached out a number of times, still working on it. It may ultimately need litigation. I don't know how else to get through to them.
So here is one of the things. If you're extending the driving license in Texas, we are not seeing any problem. If you're newly coming from other states, though, even though you may have a Florida or Georgia driving license and you want to do it, they are claiming that since you are a foreign national, they won't accept Florida or any other state driving license. Most of the Indian people do have or almost everybody has a passport stamp, otherwise visa stamp, otherwise they would not have entered into the country, though. except that some of them passport visa might have expired. They're still staying legally because they're H-1B extended, H-4 extended. What about the Canadians, though? They won't
Yeah,
have
great
a visa
question. They don't
stamping
have
at
a visa
all.
at all.
At all.
Yeah.
Even if you come on L1, even if you come on H-1B, even if you come on TN visa, they don't have a visa stamping. They don't need a visa stamping. So this may, if they don't correct it in a month or so, then we have to look into the court litigation to resolve this problem, though. That's all at this point of time, but we are keeping a tab on this one. We will keep updated on it. If things don't work out, we will start litigating this one in the federal court, though. I think so. We have to do in the federal court rather than state court, though, Emily.
Yeah. Yeah, it's definitely a new era in Texas trying to, I don't even know, it doesn't make any sense because it's not them trying to determine whether you're lawfully in the country. They somehow claim that your passport is not enough proof of identity. And it's, they're trying to base it on the Real ID Act, which is federal, but there's nothing in that that says the visa stamp has to be valid.
Emily, the $100,000 rule now, as we know that it's applicable to anybody who's coming outside the country. And when we have to do the consular processing on H-1B, we have to pay the $100,000. Now, one time you said, your team said the $100,000 is taken off. The court stuck it out. One time you said, it's not there, it's there, it's there, it's not there. Every day you're dilly-dallying. As of today, on June 23rd, today, if somebody wants to file a H-1B in the consular processing, do they have to pay the $100,000 fees?
Today, yes. The current decision blocking the $100,000 fee has been put on hold. A stay has been issued because the government is appealing that decision to the appeals court. And so while we wait for the appeals court to decide whether to continue that stay or let the lower court decision take effect, currently everything is blocked. The stay is, that is so hard to explain. The fee is not blocked. It's no longer blocked, required to be paid as of today until we get the next decision from the appeals court to decide whether to continue to allow the rule to take effect while we wait for their decision, or whether they will let the lower court decision take effect, which actually would block the $100,000 fee.
Emily,
And I think the difficulty there is the timing, because there are certainly people that were registered in the lottery with hopes that maybe the $100,000 fee would go away. We only have 7 days left to file in the cap this year. So for people that were selected who are outside the US, are we going to get a decision from the appeals court on whether the stay is going to be continued or not by June 30th? I don't know. I think there's going to be an emergency hearing on that, but whether we'll get a decision in the next 7 days, we might not, which means that the fee would be effective if you're filing in this last week of the lottery. Now, the question is, if you file without that fee, will they at least accept the petition and then send an RFE later for you to pay that fee should the fee actually be effective at the time of filing? That we don't know. So we'll have to kind of make a judgment call of whether to go ahead and pay the fee that may not ultimately be necessary in order to file the H-1B, or file the H-1B without and hope, they'll issue an RFE if the fee is really necessary.
okay, Emily, if somebody has a promotion in the company and they file the labor certification, got their I-140 approval, and if they want to get the green card, do they need to file the labor and I-140 again?
I think it really depends on who you ask that question. I would say most attorneys, most companies would say no, a promotion does not negate that perm labor certification and I-140 approval. USCIS generally accepts the fact that you're going to progress in your career over time. They realize that with priority dates back in 2013, Your labor certification for a lot of people was filed in 2013. Clearly, your job is different from 2013 to where it is now. I mean, nobody's job stays exactly the same for a 10-year window. I've not seen USCIS question the current job versus the job on the labor certification when it's clear that it is same company, same work location, and similar job duties, but a progression in the career. There are some immigration law firms that would suggest that a new perm has to be filed or the process started over because of that. But I don't think USCIS has typically taken that stance. I've not seen it, at least.
I completely agree with Emily. We have never seen any USCIS denying if it's a natural increment in the position. But if some company wants to apply for the green card and you move, the position is completely different. What do you mean by completely different? Now, if you move from SAP to .NET, it's still in the software according to us. But let's say, for example, if you're a software developer and then you become a lawyer, that's completely different. And they want to give you the green card based on the lawyer at that point of time. It may require, there are certain circumstances you can still avoid in those circumstances. But yeah, it may require for you to file the labor and I-140, only to file the 485, not for you to extend the H-1B. Anything else, somebody, before we get to questions?
Did you want to talk about things people can do to prepare for an eventual termination of employment while they still have the job? What can they do from an immigration standpoint? What should they do just from a kind of a life planning standpoint?
One thing, Emily, everybody thinks that I know about is that they are irreplaceable in their office. That's what they say. That's what they feel. And I'm very surprised that people don't have plans that if you get laid off, what are the options? Steve Jobs, I know many of the people know his name. He is the founder of the Apple company. When he was one of the richest person, he was the CEO of the company. He got fired from his company. I don't know what other example that I can give it that anybody can be replaceable. Steve Jobs, who had been fired from Apple company, is the founder of the company. He has more shares in the company than anybody else. He was let go. So there is nothing. I want everybody to plan it. Discuss with your spouse, discuss with your family. If you get laid off, what are the options? Right now, B2 is not an option. A lot of time, long time ago, before February of 2026, a lot of law firms said, hey, you can file a B2, stay here for 6 months period of time and then convert back into H-1B, including our law firm. And then it turned out that they are not approving the B2 or they are not adjudicating the B2. And from B2 to H-1B, they're not adjudicating. It's very unlikely to get it. And then a lot of people are now moving into F1 visa, which is also becoming a little bit tougher right now to move to F1 visa. But right now, under the current conditions, that definitely is an option. Now, if you have an H4 option, just go for it. No doubt, H4 is the best option. If you don't have the H4 option, F1 is an option. But everybody need to plan. Plan A, of course, you continue doing the job. Plan B, if you lose the job. Plan C, what if you have to pack up everything and leave the country? What if you apply for F1, you get a denial? What if you apply for the B2 and then you get a denial? You need to have plan A, plan B, and plan C. We are not US citizens. We are not green card holders. We are here on non-immigrant visa, which is a temporary state. The Trump administration is not in favor of keeping the H-1Bs in USA. He has put a lot of restrictions for the people who have gone out to come back into the United States. And they're putting a lot of restrictions on the people who are here on H-1B. And also the political atmosphere at this point of time, even if you are a very good performer, and if there is a mediocre performer in your company, and that mediocre performer is a US worker, they may keep that guy and let you go. The political circumstances are like that. The companies are doing that one. I strongly recommend to definitely work very hard. Never assume that you are not replaceable. You are irreplaceable person. Without you, the company doesn't run in. You are producing very high. You should be very highly regarded. You should not be taken off. Take that off. have a plan for you. And I also noticed, Emily, that those people who are taking a long vacation, when they go outside the country, when they come back, they are losing the jobs. I mean, when you're out for about 1 month period of time and they already found somebody else in this political environment, they are letting people go. That's one good indication people should not do. But they should also do other things. Now, I'm not a technical expert. I'm not an HR person. You have to do all the steps, what is required for you to keep the job. My thing is that work very hard, put 8 hours in the job, 8 hours, come back, 4 hours, you come back at home and do all the research so that you can do the 8 hours much better. You don't have, that is my advice to a lot of people but on top of that, you must have a plan. If you have a H4 plan, what is going to happen? There are some times what I see, both couples are working on H-1B, both of them get laid off at the same time. That's a danger too. What are you going to do at that point of time? What about the house? What about the car? How are you going to take care of all those things? If you have to leave the country, F1, yes, you can apply for F1. If you get F1, that's fine. What if you get the F1 denial? So one thing is that everybody is replaceable in this world. So imagine that and plan accordingly.